My name is Rachel Wall. I'm from the Human Rights Law Resource Centre, and on behalf of the HRLIC and the Castle Centre for Human Rights Law, I'd like to welcome you all today and thank you for coming. It's a pleasure to introduce Dr. Cephas Lumina, the independent expert on the effects of foreign debt and other related international financial obligations of states on the full enjoyment of all human rights, particularly economic, social and cultural rights. It's a long one, and probably a mandate that's definitely in need of a catchy acronym. Speaking of catchy acronyms, the topic of today's seminar is preying on the poor, vulture funds, debt relief, and human rights in developing countries. Vulture, at one point, was used to stand for very unscrupulous loan transfer from underprivileged countries to rich, which I reckon is a bit of a stretch. But given the interest that we've seen in vulture funds over the last few days, I can certainly see the merit in naming human rights offenders after unpopular wild beasts. But it's great to have Dr. Lumina here to share his experience in this area. The country missions of the UN Special Procedures are designed to do more than just contribute to a report that goes to the Human Rights Council. They're instrumental in raising awareness of human rights issues in government, civil society and in the community. And this function is all the more important when it comes to issues that are often invisible to those who are not familiar with the difficult to access world of international finance and who are shielded from the poverty of the people who bear the greatest burden of under-regulated and unscrupulous actors who operate in that world. So welcome, Dr. Lumina, and thank you.
Morning or afternoon, I'm a bit disoriented. A different time zone. But whatever it is, anyway, good morning or good afternoon. I want to begin by thanking the Human Rights Law Resource Centre and the Castle Centre for Human Rights for inviting me to speak here today. What I want to speak about concerns the impact of vulture fund activities on debt relief and the realization of human rights in developing countries, as well as on the need to regulate the activities of these commercial entities. I guess the logical starting point should be provide an indication of what we mean by vulture funds. Now, the term vulture funds refers to private commercial entities that acquire, either by purchase, assignment, or some other form of transaction, defaulted or distressed debts, and sometimes actual court judgments with the singular aim of achieving a high return. In the sovereign debt context, vulture funds or distressed debt funds, as they prefer to call themselves, usually acquire the defaulted debt of poor countries, many of which are heavily indebted poor countries, on the secondary market at a price far less than its face value, and then they attempt, through litigation, seizure of assets, or through political pressure, to seek repayment of the full face value of the debt, together with interest, penalties, and legal fees. The African Development Bank estimates that vulture funds have average recovery rates of approximately 3 to 20 times their investment, which is equivalent to returns of 300 to 2,000%. Although it is difficult to state with precision how many lawsuits have been instituted by vulture funds, it is estimated that there have been over 50 lawsuits by commercial creditors against heavily indebted poor countries, and many of these are still outstanding. According to the World Bank and the International Monetary Fund, 54 court cases were instituted against HIPICs, heavily indebted poor countries, between 1998 and 2008. In the majority of the cases, the court judgment had been granted for an estimated total of $1.2 billion US. And the potential impact of court awards varied from less than 0.5% of the debtor country's gross domestic product to 49% in the case of Liberia. That is the extreme end. Now, you may be wondering why I want to speak about voucher funds, given that the estimate I've given you relates to the period between 1998 and 2008. Well, I chose to speak about voucher funds because not very long ago, in fact, in November last year, there was an action involving a voucher fund in the New South Wales Supreme Court. And I'll come back to that particular lawsuit later on. Voucher fund lawsuits tend to be instituted in the courts of the developed countries, notably the United States, the United Kingdom, and France. And the reason for this is simply that these are perceived to be creditor-friendly jurisdictions. They are also instituted in these places because this might be where the voucher fund is incorporated, or it may be the jurisdiction that is stipulated in the relevant loan agreement. Action is also typically instituted in jurisdictions where the debtor country has assets, as in the case of the New South Wales action I'm talking about, or I mentioned. Voucher funds are often secretive, both in terms of their ownership and operations, and many of them are incorporated in offshore financial centers and banking secrecy jurisdictions, which are commonly referred to as tax havens. Some are owned by large financial institutions such as hedge funds, which are often based in the US, and in other cases, their ownership is rather obscure. Often, companies are established to pursue a single debt. And just to give you an example, Donagel International Limited, which sued Zambia in 2006, was incorporated in the British Virgin Islands in 1997 by Debt Advisory International LLC, which is a US-based company owned by an individual called Michael Sheehan, with the singular aim of pursuing a debt owed by Zambia to Romania. And that was its only asset. As at the time of its litigation against Zambia, Donagel was owned by Select Capital Limited, a company registered in the British Virgin Islands. And in the Donagel case, which was a case before the London High Court in 2006, the court found that the ultimate ownership of Select Capital was rather obscure, and indeed, in his testimony before the court, the owner of Select Capital, Mr. Sheehan, said that Select Capital had been set up offshore because, and I quote, many of the investors were European and did not want to be subject to US tax, close quote. Let me just give you some examples of voucher fund litigation. As I mentioned, there have been many lawsuits, but I just want to pick out two to illustrate the problem insofar as debt relief and the realization of human rights is concerned. And the case studies that I refer to concern the litigation against Liberia and the DRC, two of the world's poorest countries. Starting with Liberia, in 1978, Liberia borrowed the sum of US 6.5 million from Chemical Bank, a company based in the United States. The bank sold the debt to FH International Financial Services Incorporated and Cephas Investment Company SA, which later brought an action for the recovery of the debt before a court in New York. In 2002, the court entered a default judgment against Liberia for approximately 18.4 million US dollars. The original debt, 6.5 million, court judgment, 18.4 million. You might be wondering why the default judgment was granted. The reason simply was that the Vulture Fund took advantage of the fact that Liberia at the time was embroiled in a long-running civil war. They had no capacity to engage legal representation. There was basically the state had collapsed, so they couldn't appear before the court to defend the claim, and so a default judgment was granted against them. The judgment date was later assigned several times by FH International Financial Services and Cephas to third parties and back to the two judgment creditors. It was subsequently assigned to Hamza Investments, which is registered in the British Virgin Islands, a tax haven, and to War Capital Limited, registered in the Cayman Islands, also a tax haven. In 2008, Hamza Investments and War Capital commenced proceedings in the High Court in London to register as an English judgment, the judgment of the New York Court. On 26 November 2009, the London High Court ordered Liberia to pay the claimants more than 20 million US dollars, including interest. And while the court accepted that Liberia was short of money, and I'm using the words that the court actually used, and that the judgment date was a substantial sum, the court stated that Liberia must, and again I quote, open quote, must do the best they can. The court rejected the submission of Liberia that it had been unable to respond to the claim before the New York court because of the financial difficulties which it faced, particularly during the period of the country's civil war. The court also held that the debt rescheduling agreements that Liberia had reached with its Paris Club creditors did not affect the obligations of the state to private companies. Liberia is a heavily indebted poor country, the GDP of US dollars 870 million. It ranks 169 out of 182 countries in the Human Development Index, so it's quite poor. Over 94% of the Liberian population of more than 4 million lives on less than US dollars 2 per day, while the unemployment rate is as high as 85%. Life expectancy in Liberia is less than 50 years, and only slightly more than a third of the population is literate. The estimated adult HIV prevalence rate is 1.7%. The country is attempting to recover from the effects of a devastating civil war that include badly damaged infrastructure, as well as limited or no access to safe water and sanitation or electricity for the majority of the population. And so the judgment date of US dollars 20 million payable by Liberia is equivalent to about 5% of the budget of the government of Liberia last year. The country's entire education budget and 150% of its health budget in 2008. So you can see what sort of burden the judgment imposes. And so clearly Liberia cannot service its debt without jeopardizing its poverty reduction and economic development prospects, let alone pay an amount which the British High Court itself accepted was a substantial amount for a poor country. Next case, the Democratic Republic of Congo. And this is interesting, I think, for an Australian audience because this was the sovereign state that was sued in the New South Wales Supreme Court. And the DRC case is a tragic example of how far vulture funds can go. In 1980 and 1986, and some of you that follow international politics will remember this was during the time of the Mobutu dictatorship. During this period, the Democratic Republic of Congo, or Zaire as it was known at the time, and its national electricity company entered into credit agreements with Enego Invest, a Yugoslav company, Yugoslavia doesn't exist anymore, to provide electrical infrastructure. The government guaranteed the amount, but by the late 1980s, both the electricity company and the government had defaulted on the debts. In 2003, the International Chamber of Commerce made 2 arbitral awards in favor of Enego Invest for 18.4 million and 11.7 million US dollars plus 9% interest and the costs of arbitration. In 2004, a US district court confirmed the US 11.7 million arbitral award, and in 2005 it confirmed the US 18.4 million arbitral award. Enego Invest then sold its interest in the arbitral awards and the judgments to a company called FG Hemisphere Associates LLC, which is now known as FG Capital Management Limited. And just as a matter of interest, this company is owned by 2 lawyers that previously worked for, I think, JP Morgan. Subsequently, FG Hemisphere attempted to seize the assets of the DRC in the Bahamas, in Europe, in South Africa, in the US, and in Hong Kong. In 2005, the company obtained a court order compelling the DRC to furnish detailed information about all its assets with a value of 10,000 US dollars or more throughout the world. An order which the DRC naturally failed to comply with because it imposed a virtually impossible burden. In March 2009, the US court fined the DRC the sum of $5,000 per week and rising every 4 weeks to a maximum of $80,000 per week for failing to comply with that order. Later in 2009, FG Hemisphere brought an action in the Supreme Court of New South Wales, seeking declaratory orders and judgment based on the 2 ICC arbitral awards. And on the 1st of November last year, the New South Wales Supreme Court gave judgment against the DRC for a total of $30,156,400, well, more than 30 million US dollars, together with interest and costs. And the court also ordered that the DRC should pay arbitration expenses in the total amount of 50,000 US dollars for the ICC's administrative costs, the sum of 436 780,000 for the arbitrators' fees, and the sum of 168,000 as reimbursement for Enego Invest Defense, and another 168,000 US dollars as reimbursement for FG Hemisphere's defense. The DRC has a Human Development Index ranking of 176. It remains embroiled in a civil war. The civil war is not quite gone away. It started in mid-1997. The civil war has claimed 3.5 million lives. Approximately 79.5% of the nearly 66 million population lives on less than $2 per day. Government expenditure on health is estimated at 7.2% of GDP. And for a long time, the DRC has had a debt burden that the IMF and World Bank has characterized as unsustainable, meaning that it cannot pay its debt. And this is the reason they allowed it to go through the multilateral debt relief initiative called the HIPIC initiative. And the DRC completed the HIPIC process in December last year. And obviously, the court's judgment, and this is the New South Wales judgment I've talked about, is just one small portion of what this Vulture fund is seeking against the DRC. I think the total amount is about 100 million. And beyond FG Hemisphere, there are a number of other Vulture funds that have been waiting in the wings, and obviously because the DRC is now seen as having, sufficient fiscal space, no doubt the other Vulture funds will emerge and, want to have their share. So let me now just speak briefly about the impact of Vulture funds on debt relief and human rights. I think it's useful for me to mention that since the 1990s, bilateral and multilateral creditors have delivered or committed over 124 billion US dollars of debt relief, and this is in nominal terms, for the world's poorest countries under two main debt relief schemes: the Heavily Indebted Poor Countries Initiative, or HIPIC, and the Multilateral Debt Relief Initiative, or MDRI, which represents, on average, about 40% of the 2008 GDP of the world's poorest countries. According to the World Bank and the IMF, the debt relief provided under these two schemes have substantially reduced the debt burden of HIPICs and contributed to creating the fiscal space necessary for poverty-reducing expenditure and economic development in these countries. The countries that have benefited from debt relief have increased average spending on health and education, and now spend on average 6 times more on these services than they do on servicing their debt. So, just by way of illustration, between 2001 and 2008, poverty-reducing spending in the 35 post-decision point HIPICs increased by 2 percentage points of GDP on average, while debt service obligations declined by the same margin. From a human rights perspective, reduced debt burdens and increased fiscal space have contributed to the creation of the conditions necessary for the realization of human rights, particularly economic, social, and cultural rights, such as the rights to water and sanitation, health, adequate housing, and education in some of the beneficiary countries. And some of the human rights impacts of debt cancellation include the abolition of primary school fees in Ghana, Malawi, Uganda, Tanzania, and Zambia, which resulted in increased school enrollments in these countries, abolition of user fees for healthcare in Zambia, thereby making basic healthcare available and accessible to millions of Zambians living in rural areas, and improvement of healthcare in Bolivia and Mauritania. Nevertheless, the voluntary nature of the international debt relief schemes have created opportunities for voucher funds to purchase defaulted sovereign debts at substantial discounts and to litigate for the full face value at the expense of the debtor countries and of other creditors. In some instances, these unscrupulous creditors have attempted to coerce indebted poor countries into swapping minimum portions of the voucher fund held debt obligation for an interest in mineral and other natural resources. While voucher funds claim that these debt swaps are investments for the benefit of the indebted poor countries, the reality is that they are exploiting the indebted countries' vital and perhaps only source of income in an attempt to profit in perpetuity. And this is simply resource extortion, nothing more. Voucher fund litigation erodes the gains from debt relief for poor countries and jeopardizes the fulfillment of these countries' human rights obligations. It prevents poor countries from using resources freed up by debt relief for their development and poverty reduction programs. And we must remind ourselves that poverty reduction is a core objective of internationally agreed debt relief schemes. And so, therefore, the activities of voucher funds diminish the capacity of these countries to create the conditions necessary for the realization of human rights for their people. Money that is earmarked for poverty reduction and basic social services such as health and education is diverted to settling the substantial claims of voucher funds. It has been estimated that the average potential impact of voucher fund litigation against HIPICs amounts to 18% of spending on healthcare and education, 59% of debt repayments, and 5% of budget revenue. An organization called Debt Relief International that has a lot of experience in debt relief campaign conducted a study in 2007 which found that voucher fund lawsuits cost amount to 52% of spending on health and education, or amounted at that time to 52% of spending on health and education in the Niger, and 92% of public revenue in Cameroon. I mean, if you're talking about, a country having to part with 92% of its revenue, basically it doesn't exist as a state. In 2008, the World Bank and the IMF estimated that the potential impact of court awards varied from less than 0.5% of the debtor country's GDP to 49% in the case of Liberia. I also want to mention here that voucher fund litigation can be quite lengthy and therefore very costly for poor countries. And the preoccupation with defending these spurious claims, in my view, diverts the focus of the respective governments from pressing development, social and human rights issues. According to the African Development Bank, voucher funds grind down poor countries in cycles of litigation, and many lawsuits typically take 3 to 10 years to settle. So again, for poor countries, it's a bit much. Bearing in mind also that the issues involved in voucher fund litigation are highly technical. It requires specialized knowledge. It's not the average lawyer that will really be on top of the issues that are involved in voucher fund litigation. And so it involves these countries having to engage specialist international law firms to defend them, and those do not come cheap. Now, the need for regulation. There have been a number of initiatives that have been taken to limit the impact of voucher fund activities, both at the multilateral or international level and at the national level. At the multilateral level, the initiatives include the International Development Association, which is the concessional lending arm of the World Bank, which has a debt reduction facility which provides grants to heavily indebted IDA-only countries to enable them buy back at a significant discount commercially held external sovereign debt. There's also the Commonwealth Secretariat's Legal Debt Clinic, which provides legal advice to both Commonwealth and non-Commonwealth HIPICs. And I'm not talking about the Commonwealth of Australia, but I'm talking about the Commonwealth of Nations, which is, the UK and its former colonies, facing or likely to face litigation by commercial creditors. And the African Legal Support Facility of the African Development Bank, which provides members of the facility involved in creditor litigation with legal advice and services. Nevertheless, and it is my considered view, these multilateral initiatives are insufficient to prevent voucher fund activity. First, voucher fund litigation is not illegal. It's just litigation in the ordinary course of contractual relations. Secondly, all of these multilateral initiatives depend on voluntary commitments, not to sell debt obligations on to speculative investors, and they only provide funds or technical legal support to heavily indebted poor countries. So in this latter aspect, it doesn't really help the poor country that much. The voucher fund will still get its money, and in the process, some high-profile law firm will earn a lot of money. And just to give you an example, in the aftermath of the New South Wales litigation against the DRC, the African Legal Support Facility made available the sum of $500,000 US for the DRC government to engage an international law firm to defend it. That might only deal with one of the very many actions that the DRC is facing, and not completely deal with the problem. But significantly, these multilateral initiatives do not prevent speculative commercial creditor litigation against poor countries. And indeed, in my view, the potential for profit remains a very strong incentive for voucher funds to continue their activities. The problem is aptly summed up in the words of Mike Sheehan. This is the gentleman who owns one of the more notorious voucher funds. I quote, "Our experience and that of others in this business is that you always eventually recover." Close quote. At the national level, legislative proposals are being considered or have been adopted in Belgium, in the USA, and in the UK to limit voucher fund litigation against HIPICs. In Belgium, the Senate approved a law in May 2008 which prohibited voucher fund litigation in that country. And that law stresses that official development assistance funds are untouchable and non-transferable. In July 2009, Representative Maxine Waters introduced the Stop Very Unscrupulous Loan Transfers from Underprivileged Countries to Rich Exploitative Funds Act, or Stop the Vulture Funds Act in the US Congress, which would make it illegal for any private creditor holding defaulted sovereign debt to use litigation in a US court or the threat of such litigation to secure payment of more than the total amount that they paid for the debt obligation plus 6% simple interest from the debt the debt was acquired from the eligible poor country. In April 2010, the United Kingdom enacted the Debt Relief Developing Countries Act, and this legislation is designed to limit the ability of vulture funds to use the courts in the UK to recover debts owed by HIPICs. Now, there have been some concerns over proposed legislative controls on vulture funds. And these have largely been based on the concerns that legislative controls offer minimal benefits to the beneficiary countries, that they have adverse consequences for the secondary debt market, and that they may limit access to credit for the intended beneficiary countries. And naturally, most of these submissions have been made by those that are very strong supporters of vulture funds. I do not consider that legislation that is designed to protect debt relief gains from the predatory activities of vulture funds would curtail the secondary debt market. Rather, it is my view that such legislation would in fact enable the secondary debt market to function in a more transparent and efficient manner. And so, for example, the British legislation does not preclude creditors from obtaining recompense through the legal system for debts owing to them. It only prevents them from obtaining extortionate payments on sovereign debt at the expense of other creditors in much the same way that insolvency law does in relation to private debtors. Vulture fund activity also complicates the debt relief process and undermines other creditors by forcing debtor countries to grant vulture funds preferential treatment at the expense of responsible creditors who may be involved in debt restructuring with the debtor countries. Unlike vulture funds, responsible secondary debt participants do not acquire sovereign debt for the sole purpose of enforcing payment of usurious interest rates from impoverished countries. Vulture fund litigation and the freezing of assets of debtor countries in the course of such litigation also jeopardizes the servicing of debt obligations by the affected countries and inhibits trade and investment relations with third parties. And just to illustrate, in 2001, the vulture funds, the famous FTA Hemisphere, and another one called FCAP, sued a company called, a Texas-based oil company called CMS Nomeco, in a bid to garnish payments that CMS owed to the Republic of the Congo. This is not the DRC, the other Congo. In 2008, FTA Hemisphere Associates approached the High Court in Hong Kong to try and force the China Rail Group to hand over part of its infrastructure investment in the DRC. Now, such actions provide a disincentive for companies to trade with or invest in countries that are targeted by vulture funds and therefore harm the development prospects of these countries. Now, some have also claimed that vulture fund legislation poses a threat to property rights. I think that this argument appears to be based on the misguided notion that the right to property is an absolute right. Human rights supervisory bodies have made it clear that a state is entitled to limit or control the use of property including contractual rights with an economic value, in accordance with the general interest by enforcing such laws as it deems necessary for the aim to be pursued. And thus, for example, the limitation that is imposed by the UK legislation is a control of use rather than a deprivation, since there is no practical or legal extinction of the rights of ownership. And significantly, the Act itself does not preclude creditors from seeking reasonable recompense, but merely seeks to prevent them from profiteering at the expense of indebted poor countries, as well as the taxpayers of the countries that have contributed to international debt relief efforts. There are also compelling public interest grounds, in my view, for reducing the recoverability of debts and judgments by vulture funds. Namely, that legislation would promote fairness amongst creditors and it would promote the development in the long run of heavily indebted poor countries. I want to end with 3 final points. The first is that vulture funds are not illegal in most jurisdictions, but their activities raise very profound ethical and human rights questions. With respect to international debt relief efforts, it is my view that it is illogical to grant debt relief to poor countries or at the same time allowing vulture funds to litigate against these countries and thereby dilute the gains from debt relief. Second, the abuses that manifested themselves in the financial crisis, the global financial crisis, are the consequence of the lack of state regulation and a mistaken belief in the self-correcting power of the markets. Vulture funds are part of this flawed financial system and therefore need to be regulated as part and parcel of global financial reform. Finally, despite the claims of proponents of vulture funds to the contrary, these unethical creditors have no useful role to play in the secondary debt market. In reality, vulture funds profiteer at the expense of both the citizens of the heavily indebted poor countries and the tax-paying citizens of those countries that have contributed, of those countries such as Australia, that have contributed to international debt relief efforts. In short, vulture funds prey on the poor. Thank you very much.
Given the length, we probably won't have too many. So, do you have any questions for Dr. Lumina?
It's been a very interesting talk. Cheers. Thank you very much for a very interesting, informative talk. I appreciate that very much. You seem to be recommending legislation to limit the amount of litigation that can go on. But I wonder whether, even if that's successful, isn't the consequence only going to be to knock out one by one a couple of forums for litigation, so that if it's severely curtailed in the UK, you can't go and litigate in the UK anymore. But they can still go to the US. They can still go to, apparently, the Supreme Court of New South Wales is a pretty good forum for this sort of thing. And given the multinational nature of the vulture funds, it's probably pretty easy for them to do. So I'm wondering what you think about an international law solution for this rather than a state-based legislation solution.
Thank you very much for your question. I presented a report on voucher funds to the Human Rights Council in June last year, and this report is available on the website of the Office of the High Commissioner for Human Rights. Amongst the recommendations I made was that some consideration should be given to the creation or establishment of some form of international regime to deal with this kind of problems. But being mindful of the fact that it takes very long time, to come up with an international regime, my focus has been much more on calling on states to enact legislation, particularly those states that might be seen as creditor-friendly jurisdictions, or states where the indebted countries themselves might have some assets, because there's a possibility that there will be action instituted, to seize those particular assets. I think, for the short term, the more realistic response would be for the various countries to consider enacting legislation in much the same way that the UK and Belgium have done.
Again, thank you for a very fascinating and insightful talk. You'll be aware that the Commonwealth heads of government are meeting in Perth in October this year, and I wondered whether you saw any opportunity at this meeting to have these issues raised by the heads of government.
Well, thank you for your question. I'm not quite sure whether there would be an opportunity for me, because I'm really limited in my interventions to reporting to the Human Rights Council, and the assumption is that once a report is presented, it has been presented to the entire international community. And what I'm limited to doing really is to engage with governments, make recommendations, and hope that they can follow them up. But of course, this is something that I'm really very passionate about, and I continue to engage with the various governments on a bilateral level as well. And this is why I'm in Australia on an official mission to look at the impact of Australia's overseas aid program on the realization of human rights in the recipient countries, but in the context of the mission, and where appropriate, I've raised the possibility of the government having to look at enacting legislation like this.
You said that you, in response to one of the questions, that you suggested some sort of multilateral solution in the Human Rights Council last year. I was wondering what sort of reaction you had from the members, particularly perhaps the United States.
Maybe, well, I don't mind sharing this with you. My mandate is very difficult. Not only is the title very long, but the issues that I have to deal with are quite controversial, in the estimation of some. And this, in my estimation, is because the mandate itself and what it stands for threatens existing international economic order. And there are some states that have an interest in preserving things the way they are. And so sometimes when you make these recommendations, there's a sort of muted response. And of course, there are some countries that are affected, and they've been very vocal, but unfortunately, they are not very powerful players on the international arena. And until we can get the powerful countries, and I'm very grateful, really, to a powerful country like the UK for taking the lead, we will not get anywhere. The legislation in the US, has been before the Congress since 2009, but nothing much has happened. I suspect we may have to do with the fact that voucher funds are very generous, contributors to political campaigns. But I'm hoping that the US Congress, move through the legislation as quickly as possible. But another way, I think, of dealing with the problem is to tackle tax havens, because they facilitate the the manner in which these vulture funds operate. It becomes very difficult really to regulate them in isolation from tackling the question of tax havens, and the fact that these vulture funds can incorporate there and shroud their activities in secrecy.
We'll do one more, and then I think we'll let our speaker sit down.
Thanks. Just, I don't know if maybe I misunderstood, but in a country like Australia, say, where there's litigation in the New South Wales Supreme Court, if the debtor country, like the DRC, has no assets here, how do you enforce the judgment, or do the countries just walk away from these cases and say, well, I'm not paying?
No, in fact, you see, these vulture funds are very well resourced. They're dealing with very sharp individuals. I deliberately mentioned that the owners of FG Capital Management are lawyers that work for JP Morgan, so they know where these assets are located. It's not by accident that they brought the action in New South Wales.
So it's always where there's assets.
But I deliberately, didn't want to mention what the assets in question are because I'm not very sure. I'm still trying to ascertain what they are, but indications are that they brought the action here because the DRC has some shares in an big Australian mining concern, and so the litigation is designed, to make sure that they can seize those shares. I don't know how it's going to work.
Okay, my name's Sarah Joseph. I'm the director of the Caston Centre, and I must add my thanks to a really enlightening and fantastic speech from Dr. Cephas Lumina. I must say that until today, I personally hadn't heard of vulture funds. I should also thank the Human Rights Law Resource Centre who contacted us to co-host this event today. So thanks, Rachel, and thanks to your organisation. Just briefly to sum up what Dr. Lumina has spoken to us about today. Clearly speaking about vulture funds, which towards the end of his talk, he spoke about how they really prey off some of the poorest people in the world. And he also told us the story of some litigation involving millions of dollars in places like New South Wales, I add not Victoria, involving some of the poorest and most war-torn countries in the world, Liberia and the Democratic Republic of the Congo. And that this whole process, or vulture funds and vulture fund litigation, has really subverted the processes of debt relief, which have evolved and have been, making a difference, especially in the last decade. And I think you said that the World Bank estimates that the impact of these debts of this vulture fund litigation ranges from 0.5% of GDP, which is still a lot, 1/200th, and all the way up to 49% in Liberia. Clearly, in all cases, I would add in the 0.5% as well, a massive impact on the fiscal sphere of those countries, and therefore impacting on their ability to pay for human rights, pay especially for provision of economic, social and cultural rights. We also heard there have been some multilateral initiatives aimed at helping governments really deal with litigation. It's more sort of, it's not aimed at actually stopping the litigation. I think you said that the DRC got a grant of something like $5,000 to help them. 500. When you said 5,000, I was thinking, maybe that's 2 days worth. But still, 500,000 is nothing compared to the amount that's been awarded against them. So perhaps the real answer is really to regulate and ban these types of bodies and types of litigation, which won't be easy. There is the piecemeal approach of going from country to country, but as has been said, it's extremely difficult to move in international law at this time. Because we are, of course, hearing in favour of vulture funds the typical arguments which do come from what we call the existing economic order. the rights particularly of commercial players, things like property rights, contractual rights, credit ratings, commercial certainty. I couldn't help but think how ironic it is to name those things when you know, especially in the context of Liberia and the DRC, you're talking about debts which accrued from the savoury governments of President Vulture and Charles Taylor. And, you know, now completely innocent and very poor populations being required to pay off those debts at massive interest rates. And so I think, you know, to be talking about credit ratings and contractual rights just seems to be missing the point a bit. And personally, I agree with our speaker that it just doesn't seem that those things really should prevail over the economic, social and cultural rights of some of the poorest people in the world. Will you please join me in thanking Dr. Lumina for his talk today?